Danstan Omari, an advocate of the High Court, Boniface Akusala, an advocate of the High Court as well. We also have Dennis Ndumbi, Charles Kipkule, and Mark Pichachi, political analysts. And just before we look at some of the presentation styles, and we're not looking at the content of the presentation, it's just how the lawyers carry themselves, how they present before the judges, and this is across the board. But probably, what is this term sub judice, Boniface Akusala?
I have a different pronunciation. I call it sub judice.
Sub judice.
Actually, it is. It means that this matter is before a court, and therefore discussion of it is prohibited in other places or other avenues. It also means that this matter is being handled by court, and therefore it should not be brought to another court in another forum. Basically, dual litigation. Someone has brought a suit as against a person and takes the same subject matter before a different bench. Therefore, that the rule against sub judice, that is what it is about. Sub judice.
Yes. Even the pronunciation is a problem. and even, for example, Danstan, where does this language come from? Because we had quite a number of very foreign terms, de minimis, curata, surgery, I can't remember really, but where does this originate from?
Quite a number of legal terms are Latin terms, and law is very foreign to us. We just started getting law in this country around 1901. So the most of the terms that have been settled, the language is foreign, the terminology is foreign, the conceptualization and the semantics of the law is Latin and other languages. And that is why you hear many of that. Look at that Catholic Church. You'll get that most of the terms used in the Catholic Church are more Roman and other languages. So that is how it is. And it is not only in law, it is in almost every discipline. You go to media, you go to statistics, you get that the language, the terminologies in those languages are foreign, because we have simply taken almost everything. Number two, when we talk about sub judice principle, I want Kenyans to understand that originally, before today, the judges and the advocates were not trained graduate people. They used to be clerks who could graduate to become judges, who could become advocates. Remember, this is the transition from the church, because the church was the custodian of justice. Then out of the church, it started heading towards having specialized people doing law as a secular aspect. So it was almost banned to discuss any matter, because these people had no capacity to sustain the arguments outside. So that is why the rule of sub judice has been as old as that. With the coming of the Kenyan Constitution, that matter has been litigated, not in the Supreme Court, but in other courts. And some decisions from the other courts are saying judges are trained. They will not be influenced by any arguments you people will be having on the media. But that is why I'm saying, as we move further in this discussion, we'll be looking at the personality of the judges and the mode, how they look at law. Is it from a conservative point of view, or is it from a progressive point of view?
But do you think by looking at the approach that particular judges or particular advocates use, their kind of approach to a matter, would be sub judice? Because then we'll be like judging them, and they're expecting that if at all this person has this background, then the judgment will go this way.
I'll tell you that up to the Court of Appeal, the rule of sub judice has been watered so down that people are saying, the courts have said, you'll continue doing what you're doing. I read and I make judgment based on the pleadings and the evidence produced, not the history, not the case that you are making out. The Supreme Court has pronounced itself on this matter, that any discussion of this matter is called sub judice. That means that the Supreme Court has embraced the conservative definition from the doctrines of the common law. Common law is what the law we got from Britain. That is the position. So we have two conflicting matters.
But on this particular issue, because we say Justice Maraga has, as the Chief Justice, has pronounced himself on that matter with regard to sub judice, therefore we run the risk of
Yes.
actually offending the court if we discuss those matters?
If we discuss those matters, we risk what is called contempt of court proceedings. This happened in 2013. You remember when the former LSK chair, Mutua, made some utterances, and he was summoned to appear before Justice Mutunga, and surprisingly, they did not find any ground to convict him. I don't want to challenge the decision of the Supreme Court. It is the law.
Yes.
The apex court has said any discussions is sub judice. But I hope the lawyers who will be in that court will pursue that further for that to be defined. Because when you look at Article 35, the freedom of expression, up to what level do you gag Kenyans from talking what they want to talk? Are we likely to go back to the Public Preservation Act that used to say that that is causing disturbance or creation of disturbance? So in my own view, the Supreme Court has spoken. We cannot discuss the evidence. We cannot preempt the judgment. We cannot criticize whatever is going on. Our role is only actually a conveyor belt to give a fair comment.
Yes, and that's the kind of approach I want us to have, my entire panel, as we look at the lawyers making their presentations, because we are not looking at the content, we are not looking at what they're saying. It is just the kind of style of how they make the presentations before the judges. And if my director could help me with some of the bites from the lawyers representing the petitioner, NASA, then we'll look at some of those clips from the lawyers representing the first respondent, that's the IEBC.
For a day in Kenya when after elections, instead of conflict or disputation, each side can stand up and say, yes, I concede defeat, but I concede because the elections were conducted in accordance with the law. And we got to put our foot down.
If, as by law provided, these results were coming randomly from across the country, then it would not be possible to have such a consistent gap. By the time of declaration of the final results by the second respondent, Mr. Chebukati, there were 10,480 Forms 34A that had not been received. The final declaration of the result by Mr. Chebukati, was not supported by Forms 34A.
When we talk about an election being accountable, our proposition is that an election is accountable if it is capable of being scrutinized from its own records. So in the context of an election, for instance, the national tally must be able to be accounted for from the tally from the constituencies. And the constituency tally must be able to be authenticated by the polling station tally.
In an election, those who are in public service make a choice to serve the people of Kenya without any discrimination at all. And they must at all times show neutrality.
And my submission is then that the lead extended from 8,400 in 2013 to 1.5 million in 2017. And if the question was that you can do anything so long as you display numbers that are difficult to offset, then elections become a purely political issue rather than legal.
After every election, there's always lack of faith, lack of confidence. And the only way we are going to cross over the bridge is that anytime there's a transgression of the law in relation to the elections, this court should not hesitate in.
Those are some of the lawyers representing the petitioner in this case, and that's Raila Odinga. Let's now listen to some of the presentations by the lawyers representing the first respondent, that's the IEBC.
And your leadership, what you have before you, in my respectful submission, is a petition that is dead on arrival. That
in a dispute relating to presidential elections, the fundamental issue for the court to ascertain is the will of the Kenyan people when they exercise that sovereignty.
That we have demonstrated through the various affidavits that this petition is destitute of merit. And because it is destitute of merit, it should suffer only one fate, the fate of dismissal.
Where there were some instances of something in the nature of evidence has been wholly answered and demonstrated as having been incorrect information, untrue information through us when we were pointing out.
We submit that the variance is accounted for by the following. Number one, the diaspora voters were only voting for the presidential candidate. Number two, the prisoners were only voting for the presidential candidate.
The Court of Appeal was clear. Once the first respondent had collected 290 Form 34Bs, they could then go on and...
Polling stations, and some of those polling stations that have been referred to by the petitioner do not exist. My Lord, I repeat this for emphasis. Read paragraph 192 and paragraph 200 of Immaculate Kasait's affidavit. Those allegations, those are not gazetted polling stations.
Allegations have to be proved by concrete, admissible evidence. That is something that the petitioners have wholly failed to do.
People of the Republic of Kenya on the 8th day of August did express their will, and the first and second respondent did midwife. Remember, your lordships and your ladyships, ours is midwifery. We delivered a baby. That baby is alive and well. You are being asked to strangle the baby. Decline the invitation. Decline the invitation because the baby is alive and well.
The result as declared, in fact, where there have been posting or transposition errors, we have considered this in the affidavit of Immaculate Kasait, and the respective presiding officers have sworn affidavits explaining the circumstances under which the errors were made. There were innocent mistakes. The numbers are very insignificant to the final result.
Yeah, but some of the lawyers representing the IEBC team, which is that's the IEBC, which is the first respondent in this presidential election petition. Remember, the third respondent in this petition, that's President Uhuru Kenyatta, will be making, his legal team will be making their submissions today. That's from 11 a.m. when the Supreme Court sits. But now, just looking at the some of those lawyers making their presentations, are not really listening. I know we cannot avoid just to listen to what they're saying, but it's the style of presentation that I want us to look at, and the way they make, because quite a number of lawyers have spoken there, some quite in low tones, some very animatedly, and even as some of the viewers were watching this from home, you can tell when the interest goes up, just to capture that kind of interest. Mark Pichachi, this is not in any way a very boring petition, if I must say. These lawyers are very entertaining in their own ways.
Absolutely. You know, one of the things that is very cleverly shrouded in the use of Latin, by the way, just to give Dunstan Omari a lesson, because he learned, but let me learn him some more. The clergy and laity division was a very naughty thing within the early Catholic Church, in the sense that the clergy learned Latin and the laity did not know Latin, and therefore they did not have access to the Bible, which was written in Latin. And that's why Martin Luther became a very historical figure, because when he read the book of Galatians, was able to translate it for the common man and protest. And therefore, we would like to protest one day from this learned oppression. Having said that, having said that, in the court case that was there yesterday, you know, one of the hardest things to do in this country is to be pitched against PLO Lumumba in the war of words and language and grammar and vocabulary. You know, I doubt there's any Kenyan alive who is able to do that. In fact, the person who could have been able to do that was the late Wamalwa Kijana. He was quite good at eloquence, and that's one of the things that you have to take home, because one of the things that you will realize as the public is watching this show, for them they're looking for highlights, for them they're looking for punchlines, for them you remember when we used to play Mchongoano when we were kids, and one person is going after the other and they'd say, oh, your head nikama njugu, or okay, you can't chew gum and walk and things like that. So what the public was looking for is, where is the punchline? That is the entertainment value. And of course you will see today there's a lot of hashtags around babies and certain things because of the entertainment value. Now the question of course will later be discussed as to whether that was a merit in the case, and we'll not discuss that. But in terms of waxing lyrical, PLO Lumumba would come out number one, and then of course you've got James Orengo with his usual flair and his usual use of legal terms to be able to endear both, because he's a politician, so you could see him playing both to his legal profession but also playing to the gallery, in the sense that he knows he has supporters and he has to deliver something to his supporters. And the narrative was very clear, in the sense that the entertainment therein was to keep the Kenyan person glued, because at the end of the day, you not only want to win a case, but you also want to win the PR angle that is experienced throughout the country.
Yes, Charles, of course it's very entertaining to watch the lawyers, but this kind of flair should count for something. Do you think, would you go for a lawyer who does not present himself that way? Because they all have a way they're using their hands, and this is across all teams, from the IBC team, Raila Odinga's team. They all do this when they're talking, so it's it's like they're conducting a choir, though. Yeah. Charles?
Yeah, I think that goes back to this tradition of legal practice. I think it is something they look at. They want to measure themselves against a certain standard that has been there. But if you ask me, if I'm to look for a lawyer who can be able to push a strong case, then we want to look at someone who will say something that will be remembered. Because now when the judges retire to make their judgments, apart from what has been recorded and everything, they may want to say, okay, who said something that is really sticking to me? And one of the things that stands out when you look at presentations made by Dr. PLO Lumumba, one of those, you may look at them and just think there is entertainment value in it, but apart from the cadence, the diction and all of that, there are some things they will say which will stick. But again,
but it does matter, the diction, and that's the other question, yeah? Is it a requirement for a lawyer, for an advocate, to have that kind of enunciation, that kind of ability to be so articulate? Does that then write off some people from this profession?
I think basically that's become probably an added advantage, because when you see a lawyer who does not have diction, then they become combative in court. And then now you just have to adapt yourself to the situation and look at your competencies and see, if I come to this courtroom and I'm not very good in terms of articulating the issues probably in Latin, as a PLO does, then I become combative. Or if I'm not combative, then I really show that I have strong command and knowledge of the law. Even if I put it across in a language that is not very clear, then the issue is I've made reference to the law and my standpoint is the law.
But clarity is key, Bwana Dennis Ntumbi. In any kind of communication, clarity is key, whether you're a politician or a lawyer. And probably the more articulate a lawyer is, the better, because we are seeing very articulate lawyers this time round, and we still await to see Fred Ngati and Ahmed Nasir Abdullahi making their submissions today. All this senior counsel, looking at them, they're all very articulate.
Certainly the articulation is there, and I think you need to have this technical capability to articulate your diction more, but also contemporary understanding of the law is key. But I mean, for me, my heart grieves just a little bit. For one thing, the question before the court is actually a moral question. And if you look at it, the fact that a moral question is discussed from a very, very technical perspective, that my grandmother can't understand what is happening in the court, the invasion of foreign tongues in our legal system, certainly. Why can't we have quotes from the Luo, from the Luya, from the Embu, and just the disregard of our traditional wisdom? Why do I have to quote Greek so that it becomes entertainment thereabout?
But look at it this way, Dennis, because this is a matter before court, and it's just as well the session would have been behind closed doors. It's only that the media this time has been allowed to.
I certainly understand. What I'm saying is, if you look at and I said that the question before the court is a moral question. If you look at some of the election laws that are being debated, and the question has been debated, it came all the way from 2007, where the Kriegler report was formed, the electoral laws were formed. We are certainly trying to, medicate a moral issue in this country, but using a lot of technicalities. I think for me, one of the things that I want to see addressed and going forward is that the technicality around such cases is certainly addressed, and the standard Kenyan person is able to understand the proceedings around the court, because this is highly and I've been asked as a politician, a lot of people ask me what is going on, what have they said, and sometimes what we're able to borrow is the Greek around it, and not the moral solutions that we're trying to medicate. So for me, I'd like to see, and to be very honest, for a long time I've been asking whether, and my learned friends here can answer, whether we can have a jury system in this country, whereby you have the church involved, faith-based organizations involved, you have traditional elders involved in such cases that are weighty, so that the moral question that we are trying to address through the electoral process and through electioneering in this country is certainly answered. But what people are trying to see in all this jargonism, in all this intellectualism that we're saying, is certainly solving a moral problem in this country through all the technicalities and all the jargonry we are seeing. And for me, Fred, that's the question I'd love to see. And suddenly it's amazing to see all the flair, to see all the amazing brains, and I'm sure today a lot of people will be glued, but people are just getting glued to see what can I tweet, what can I put on Facebook, what is funny,
what is the highlight,
what is hilarious. Oh my goodness, PLO has come in, this is the way people run towards the TV. But we're trying to resolve such a critical moral issue in this country, and all that sometimes disappeared. So I want to see the legal proceedings and dress from all these, from a technical rigidity to somewhere where my grandmother can be glued on TV and say, you know what, I think these guys are going to help us.
Okay, but Boniface Akusala, is this thing taught in school, the kind of flair in law school? Because, or do you just adopt it on the way as you, so probably it's a matter of experience. The longer you've been in the legal profession, then your flair gets finer, because is there something like LLB flair 101?
First of all, I don't want to go back to the debate of learned because that is an important component, because if you've gone through trial advocacy, civil procedure, criminal procedure, you will be taught how to present, you will be taught how to drive your point home. But then again, it is just not about oratory flair. It is about how to convince, how to present your case to make it believable. And to us, we do not, that is why we have a problem with the ruling about sub judice, because it's the duty of media and duty of the church to translate what has happened in court to the common mwananchi. But this is a court of law, it's not a court of morals, and therefore I definitely take issue with the allegation that it's a moral question. These are legal questions. Constitutional, electoral laws are being challenged, and we are seeking interpretation in view of these laws. Therefore we cannot water it down to look like we are trying to moralize our society through the petition. The courts, as it stands right now, you'll find there are different kinds of presentations. There are those who are fiery, there are those who would want to take it through an irregular terrain. They would scream, others would shout, others would go quietly. It is a mode of presentation depending on the point you're making. It is not constant. Yeah, so you'll find at one stage PLO is shouting, the other stage he is whispering, because it depends with what point he wants to be taken. There is nowhere you are taught this is how to speak. It comes with how you are influenced while growing up. But the way to present a case is something that is taught in school. Yes. That is why, again, part of the learning.
And it is part of the learning, because even Dunstan Omari, when he's in the panel, there's a particular way he talks. Yeah, there's the way he shouts. There's a particular way he talks, and he ensures that everyone else has to keep quiet for him to talk. Dunstan, how has your experience been? How did you come to learn of that? Or did you learn it from your the people who are senior than you in the profession? Probably you borrowed it from somewhere.
I'll tell you, Fred, for free, and for the Kenyans for free, that a court of law is not a court of law, it's a theater. The people who are there, the judges, the lawyers, are actors. And therefore, that theater becomes the theater called a battleground. It is a war. The war to convince the judge to see your point of view. The war to convince the judge is one, verbal and non-verbal. Is emotional, is intellectual. So when you look at those lawyers, they have 7 judges, and those 7 judges come from different mindsets. Those different mindsets are addressed by the type of lawyers you are seeing. Let us start with one by one. Let us look at the NASA team. When Orengo talks, look at the area he was given to talk. The historical constitutional fight from single party to today. And he reminded the judges that there is a time they didn't have security of tenure. Today, he's trying to tell them that, look, I'm part of why you have that job. When you come to the eloquent Otiende Amolo. Otiende Amolo has been an ombudsman, a technocrat, an administrative person. Look at the role he has been given. He is very factual, very statistical, very clear to the point. Different from Orengo. When you move to Mwangi Paul Mwangi is put there to represent the political aspect. That even when his name does not appear to be a NASA follower, he is there politically to show that NASA is a national outfit. Look at his argument. Paul Mwangi has dealt with the cases of Raila Odinga all through, and he understands the philosophy and the thinking of one Raila Odinga even when he was a prime minister. When you move further, you come to Professor Mutaha Kangu. Professor Mutaha Kangu and other professors who are there, people like Professor Gidu Muigai, Professor Mutaha Kangu, Professor Sihanya, Professor PLO Rumumba, they know very well that within the judges, they are professors. Professor Juang is there, Dr. Smokin Wanjala is there, so they and Njokindungu is there. All these are intellectually stimulated judges. So you have got to blend your case to have the intellectual issues. And you saw Mutaha Kangu saying, in my book of constitutional interpretation, which the judges will refer to. So that is the lineup. When you look at IBC, Professor PLO Lumumba comes up and says, I've got to bring humor and I've got to bring life into this thing. He moves ahead to bring that life. Whether the court was listening is another issue. For those students, when I was teaching in secondary school, there is a book called No Longer Tis, where one Obio Konko, who had done English, and when people came, because he had 2 degrees and was coming back to Nigeria, people came to hear the English. The clerk who didn't have a degree spoke the same way PLO talked. And people were cheering, not because they were hearing and understanding, but because they were not getting the point. But they were getting the serious semantical arguments that were there. When Obi came, he said, yes, is. People were annoyed, but they understood everything. So did the PLO communicate? Communication, Fred, and you are the experts, is that the audience must get what you are saying. If the audience does not get what you are saying, because you have put vocabulary after
but
vocabulary.
But in this case, Dunstan, the audience for the lawyers is definitely the bench.
That's what I'm saying. The audience for the bench, you really have got to know.
They definitely understand that
Are
kind of
they understanding, or are they saying that you want to demean them, that you know much? That is number two. When you look at the next IBC lawyer, Senior Counsel Paul Mwite is very articulate, slow in talking, dragging his words, but the words pierce the heart and the minds of the judges. He is coming from the history, like Orengo, where they were fighting on the streets. And when he talks of judicial restraint, he is reminding the courts that, look, there's a time that the judiciary was not like this. So when you look at the composition of the lawyers and why they are picked, it is majorly on one issue: who is the bench? When you look at Mansour is a serious technocrat, a figure person, and you saw how he demolished all the arguments of NASA, word to word, paragraph to paragraph. He was just reminding them, in this paragraph we have answered it this way. He also conceded. There is the issue of conceding that, yes, we concede. Here there was a miscalculation of one vote, but with that one vote.
But I'm not so sure we want to go into what exactly he said yesterday, because I'm really scared about that issue of subjudice. Yes, time for us to take a break. We'll come back to discuss the issue surrounding time. We are seeing the court sitting till late into the night, and that also affects their mornings, because now today are starting at 11, simply because yesterday they sat up until some minutes past 8 p.m. What does this mean? This 14-day period for presidential election petition, is it enough? One of the lawyers raised it. Of course, that is not a matter before the court, because matters of constitutional amendment are handled elsewhere, not by the Supreme Court. So we'll be looking at that as well. Remember, you can still send in your questions with regard to this, and also the ban on plastic bags. Use the number 22422. Texters, use the hashtag Power Breakfast. Let's take a break. Power Breakfast continues.